Here's the truth about asset protection that no one wants to admit, and it is not everyone needs a Wyoming or Delaware LLC. Hi, and welcome back to the Wealth Planning Podcast with Brister Law. My name's Anthony Brister, and I'm a tax and asset protection attorney. Today, I'm breaking down one of the most misunderstood tools in business and asset protection, and that's charging order protection entities, or COPs. So, what is a COP? When do COPs work? And when are COPs oversold? And most importantly, how can you avoid falling into the hype? So by the end of this episode, you'll know if COPs are right fit for you and your situation, and when to skip out on the COP, and what might be a better option. So let's start with the basics. All a charging order protection entity is, or COP, is a legal entity. Think LLC or partnership that's designed to shield your assets from creditors. In certain states, they recognize them, and creditors can only get what's called a charging order, which is essentially a lien on distributions from that entity. The idea is simple. If there's no distributions, the creditor can't get anything. But here's a catch. Not all states treat COPs the same. A charging order may be an exclusive remedy in states like Nevada, Delaware, or Wyoming, but other states allow creditors additional remedies. Also, if your state or your LLC isn't registered in the state you're doing business, that state isn't going to respect your entity. So knowing these rules is very, very important. So when should you use a COP? Well, COPs can be a very great tool if you have high-risk assets or you're in a high-risk profession like a real estate investor, a lawyer, business owners, litigation-heavy industries. These LLCs really are supposed to hold assets and non-litigious assets at that. You must operate in a state that has strong charging order protection laws like Delaware, Wyoming, Nevada, if you've got an operational business. If it's holding assets, different rules there. But remember that the COPs don't protect you from all risk. So they won't protect you if you sign a personal guarantee. They're not a replacement on insurance. And if you're not following the formalities, you're not going to get those protections. So why are COPs oversold or overhyped? Most of the time they're sold by advisors, typically non-lawyers, as a magic bullet for asset protection. One myth is you don't need anything else for protection when you've got a COP. COPs are only one tool, and without proper insurance, business structuring, and following the formalities, a COP isn't going to be enough. You need to make sure wherever you're operating your business, if you've got property, that LLC that's holding that is registered in the state that you're doing business. Another myth is that they work equally in every state. So states like California or other more liberal states might not offer the same protection as Delaware, Nevada, or Wyoming. So just be sure to talk to an attorney and explore all the options available for you. So when does a COP make sense or not make sense? Well, if you have low value assets, you probably don't want to spend the money on a COP. If your state has weak protections or offer different types of protections, you might want to explore those. If you want to maintain low cost and keep things simple, a more simple structure might just be a LLC in the state that you live and are doing business. But COPs are great tools for asset protection, only in the right circumstances. So don't let anyone sell you without considering all your needs and kind of where you're at. If you're curious about more asset protection strategies, I'd love to meet with you. Go to bristertaxlaw.com, schedule a discovery call. My name's Anthony Brister. This is the Wealth Planning Podcast. Thank you for tuning in. Don't forget to like, subscribe, and share with anyone who might not really know why they have a Wyoming LLC, or they might be telling you to go out and form that Wyoming LLC without knowing why. Thank you.